Please be seated. Good morning, I think, still? Yeah. We are here for oral argument in case number TX18 3, 100 VAL VISTA versus PINAL. Counsel, each side has 20 minutes for your argument. The appellant may reserve time. I would just ask that you keep track of that with the clock on the podium. The proceedings are being recorded, audio and video, so if you would tell us who your client is and who you are when you come up to the podium, that would be appreciated. We've read the briefs, discussed the issues in conference. Please keep that in mind as you make your briefs, make your argument, and with that, counsel, you may proceed.
May it please the court, counsel. My name is Roberta Livesay, and I represent Pinal County. To the fullest extent possible, I'd like to reserve 10 minutes for rebuttal. And from the outset, I'd like to point out there is an error in the opening brief at page 6, where I stated that the county classified this property as vacant commercial land. The word commercial is superfluous there. There's no such classification. It's simply vacant land. And one other prefatory comment, please remember that any time during arguments or in the briefs, any pastures are named other than Val Vista. For instance, we have Laguna, we have Pickering, we have some other pastures. None of those other pastures are part of this litigation. The only property that's under scrutiny here is the Val Vista property. So the Val Vista pastures will always be referenced as subject property or Val Vista. Any of those other names, those are outside the purview of this case.
Counsel, are you saying that Val Vista has to satisfy independently all 4 elements and that each individual property has to satisfy?
No, not at all, Your Honor. We know that agriculture is very important to the economy of the state, and because of that, we have some very beneficial property tax treatment for legitimate agricultural property. But you do have these requirements that have to be met. Now, a parcel of land or an area of land that's contiguous can satisfy all 4 requirements on its own. But if that property can't satisfy those requirements on its own, as long as it's used with a greater ranching operation in a way that makes a functional contribution to that greater ranching operation, it can enjoy the benefit of the agricultural classification. Now, we filed a motion for summary judgment in these proceedings after discovery and disclosure had ended. We were given no evidence of one of the prongs that had to be satisfied, which is a reasonable expectation of profit. We'd asked for that material. We'd asked for income tax returns. We'd asked for profit and loss statements. We'd asked for planning and scheduling and grazing rotation schedules and things like that. That would have given us an understanding if that requirement could be satisfied. And we got nothing. We had absolutely nothing. So we filed a motion for summary judgment and said, here's one of the requirements that has to be met. There's no evidence. And in fact, the rancher, who ranches on, according to his own testimony, ranches on about 70,000 acres of land. He testified at his deposition and again at trial, but for now I want to just narrow it down to the summary judgment proceedings. He testified that he could not recall ever having made a profit. He said that he hoped to make a profit one year in the realm of about $50,000, and then later on they produced an affidavit. This is after the summary judgment, saying that in a couple of years he hoped to make about $30,000. But his sworn testimony is that he can't remember ever having made a profit.
Individual, the owner?
No, he's not. He is someone who holds a lease for the subject property.
Doesn't the statute require the owner to file?
Actually, if you look at the form that the Department of Revenue prepared, it has a place on there to check if it's being filed by the owner or filed by a lessee. So, again, the Department of Revenue and the counties recognize that very often these wide swaths of land are not used in an agricultural manner by the actual owner. So a tenant is allowed to satisfy that requirement because the law looks to the agricultural operation. And
Look at the words in the statute, and it says, shall be satisfied if the owner files. It says nothing about a tenant or anyone else on the land.
we're not disputing that. Yeah, I don't think that's even an issue here. The owner can file the affidavit. Again, we have no problem with that. But the cases that we cited about filing an affidavit say that it has to be based on personal knowledge, and you have to show that you've examined something. If it's not your own information that you're looking at to avow, then you have to examine something that would tell you that what you're saying is true. We know the owner here could not have done that because they never disclosed anything to us. So if the owner was looking at these books and records supplied to him by the rancher, why didn't the owner give them to us?
Of that law, though, the new statute that says this requirement shall be satisfied with an affidavit, isn't the intent to circumvent the need to present other type of evidence?
Well, as the appellees were so kind to produce some of the legislative history in their answering brief, and you look at the video of that legislative history, you can see there's two people who testified to it, Senator Griffin and VAS Aha, who was the head of the Arizona Cattlemen's Association. What they were trying, the evil they were trying to cure, was an overzealous assessor going in and asking for all kinds of documentation up front before the property ever got put on the tax rolls. That's not what happened here, and Pinal County never actually did that.
But the resulting legislation just says this requirement is satisfied if you submit an affidavit that says there is a reasonable expectation of profit.
Well, that's certainly what the trial judge found, Your Honor, but I think that it is a ridiculous conclusion to assume that the legislature would allow for a false affidavit to satisfy the requirement.
Different remedy, if you want to go in and charge somebody with fraud for filing a false affidavit, there's nothing that prevents the county from doing that, is there?
Well, that's one of the statutes that we cited both to the tax court and in our briefs, and it's 42-121-53, I think, but please don't hold me to that. If the county finds out that a false affidavit has been filed, the county can go and investigate and back charge for the full amount of the taxes plus penalties.
Well, so why isn't that the appropriate remedy? It seems to me the statutory scheme now just contemplates that if the affidavit is filed, it satisfies that one requirement. And unless the county can come in and show that this was a fraudulent affidavit, that was the point of the legislation, was to avoid having the need to file additional documentation to show where the profit is going to come from.
But that avoidance occurs before the property is put on the tax roll. In this case, the property was put on the tax roll as vacant land, and the taxpayers sued. According to the testimony that was before the committee that they utilized in helping them to decide whether or not to enact that amendment, both Senator Griffin and Boss Aha said, of course, if there's a wrong affidavit or if the assessor has problems with the affidavit, the assessor can go in and investigate. And specifically, Mr. Aha said, if it goes to litigation, the assessor can request Schedule Fs. Well, we requested Schedule Fs. They sued, took us to litigation. We requested that information and never got it.
And all of this, all these documents, Schedule F, it's evidence of what?
I'm sorry, Your Honor, I couldn't hear the beginning of your question.
The schedule, all these documents, that's evidence of what?
Of the profitability or lack thereof, or the reasonableness of an expectation of profit.
Right. But isn't that important, that it's expectation, aspirational? It's not proving decimal point profit, or is the county saying it has to be profitable, and so we only want to reward the winners?
No, Your Honor. According to the Title USA case, the test is an objective one because of the great potential for abuse.
But that was the test before we had this new provision that said the requirement is satisfied with an affidavit.
That's correct, but the reasonable expectation of profit requirement has always been there. And here we've got a rancher who is ranching for 40 years.
But the requirement is imposed by the legislature, and if the legislature wants to come in and say you can satisfy it by filing an affidavit, it seems to me your interpretation reads the new provision out of the law. If you can come in and say, well, that affidavit isn't really supported, we need some documentation to show that.
No, Your Honor, I respectfully disagree. you have to keep in mind that the property is put on the tax roll with an effective date of January 1 of the valuation year in question. This requirement is satisfied in order to get the property on the tax roll. Once it's on the tax roll, then if the taxpayer sues, maybe he thinks it's still too high, and we go to court, or if the assessor doesn't follow that affidavit and we go to court, it's trial de novo in tax court. And the 4216250 says that at trial, the court can listen to any evidence that has to do with the valuation or classification of the property. So we've got a whole bunch of other statutes. You can't read this statute in isolation. You have to read it in paramateria with all the other statutes, not only in that chapter, but in Title 42 that impact it. And to conclude that you can do it by a false affidavit flies in the face of integrity of our statutes.
Let's talk about then what the shall statute did do. What did it do? Did it change anything?
Yes, it changed it so overzealous assessors wouldn't require a deposition of an applicant before putting the property on the tax
It has
roll.
to be an overzealous. At what point does it become overzealous?
Well, that was Senator Griffin's word, so I just picked up on her word.
Reading the language seems to say it shall satisfy that requirement. I don't see it as if it shall satisfy it if there's an overzealous assessor. It seems to just be saying that satisfies it. And there's still other requirements where you're not automatically qualified. You don't qualify for the tax benefit simply by virtue of the affidavit. There are other requirements, but it seems like the legislature has said as to this one requirement, this one is satisfied. If you can later prove that that was a false affidavit, then we'll come in and revisit it, but we're not going to do that as part of this process.
But that's not what happened here, Your Honor. First of all, the affidavit wasn't signed until 2.5 years after the date of value. I never saw it until the summary judgment proceeding happened, and they attached it as an exhibit.
In your view, it would be different if that had been signed 2 years earlier? That changes the analysis of whether there's a reasonable expectation of profit?
Not the analysis as to whether there's a reasonable expectation of profit, but the manner in which you prove it at court. And here the tax court said the county wasn't even allowed to bring up the subject during trial. The county was foreclosed from defending.
If it had been signed 2 years earlier, in your view, could you still have come in and said, well, we need additional documentation, we're not overzealous, but we need some additional information?
I think in this particular case, and I want to limit it to these facts because this is all that I can really talk about, we know that the property itself, the subject property, could not sustain the required number of animal units. So the additional information that the assessor might have
different prongs.
It is.
What does that have to do with whether the affidavit says there's a reasonable expectation of profit?
It raises a question in the mind of the assessor as to whether or not there is a reasonable expectation of profit with regard to this land. So, Mr. Taxpayer, come in and show us how you are earning a reasonable how you have a reasonable expectation of profit in your greater grazing operation, how you use this property as a functional contribution to that greater grazing operation. We'll take at face value your affidavit if it was signed before the property was put on the roll. If it's signed, which didn't happen here, but if it's signed before it goes on the roll, we will take that at face value, but we still have 3 other requirements, and we want to see how you're satisfying those, because we also have this requirement that the assessor has to go out once every 4 years and look at the property, and we've been out there, and we don't see that it's really being used in a way that satisfies the statute. So let's look at the totality of the circumstances.
Yeah, so a quick question for you. If you know, why didn't we receive any amici from your fellow counties or anyone chiming in on your, it seems like a very significant argument here. Is that significant?
I don't know the answer as to why there are not amici briefs in this. Okay. I just simply don't know.
And then let me give you a hypothetical. Let's say you have somebody who has an agricultural operation, and they've gone 20 years and never once made a profit. Are they entitled to the classification?
I think it certainly raises a question as to whether their expectation of profit is reasonable, and that is what we have here.
So there's an orange grove that's been out there for 50 years, and it's still an orange grove, but the trees just aren't doing very well. You can come in, and we're going to challenge that aspect of it. Even we don't think they're really making a profit now, but it's still an orange grove. It's been there for 30 years.
I don't think I've got enough information there, Your Honor, to really answer that, but maybe I can answer it this way.
Or they're a bad businessman or businesswoman.
Right. If they're a bad business person,
No, a bad business, just a bad.
Let's say we've read
that's why it's an objective test, Your Honor.
Let's say we've read stories about them that say they've lost money 10 years in a row, but it's clearly they're growing. It's a citrus grove. We can come in and say you don't qualify for this tax rate because we see that you've lost money for the last 5 years. You're a really bad business person.
That's why the test is an objective one. But here we've got a rancher.
What does that mean? I mean, so 20 years, not 1 year of profit. Poor businessman. Doesn't get the distribution contracts in place, and he's not getting it. Are we saying that bad businessman is not entitled to a tax credit? Or to their lower tax?
He's not entitled to the tax benefit if a reasonable person operating under the same conditions of the land that's before him and the market possibilities that are out there would not be able to make a profit. And that's why we had an expert come in. This strays way from the summary judgment motion, and I only have 4.5 minutes left, and I would like to save some for rebuttal if it's okay with you all. Thank you.
Good morning, Your Honours. May it please the Court, Counsel. With me, I'm Paul Moore from Mooney, Wright, Moore and Wilhoit on behalf of the taxpayer plaintiff appellees. At counsel table with me is Mr. Wright, and sitting on the second row is our client, Mr. Yount, and Ms. Callahan, who are owners of the property. I'd like to address the affidavit issue and the statute regarding the motion for summary judgment, which is, counsel has just taken time with. The statute is plain on its face. You don't have to go to intent. If you were to go to intent, Senator Griffin, is clear that the whole purpose of the statute is to stop the intrusion into documentation and asking for documentation. The statute says that the owner must file the affidavit and sign it. Mr. Yount signed and filed the affidavit with the assessor. The assessors, we had that in 2 different places in the statement of facts during the motion practice, that the affidavit was filed with the assessor's office. Both times it went uncontested. And
what in your view is the remedy if there's a patently false affidavit?
Well, that's not in this case, and if there is a patently false affidavit, then they have to investigate that. Mr. Yount was noted as a...
That would be a separate proceeding, presumably.
No, I think in this case, if they thought Mr. Yount's affidavit was improper, false, without grounds, they could have deposed him. They could have... he was named as a witness long in this case. Everybody knew about him. Bring him in.
The statute isn't dispositive on the element.
Say that again?
So we have 4 elements, right, for this classification. One of is expectation of profit.
Yep.
And then we have the 2002 statute. You're saying the statute 2012 isn't dispositive and that discovery is permissible if there is some fraudulent indicia.
No, I think it's 2 parts. I think it is dispositive without some kind of proof of fraud. I don't think I could stand here and say if somebody put a fraudulent affidavit before the court, it would be like in any other proceeding. If it was fraudulent and you could prove it was fraudulent, I think you would have an opportunity to figure that out.
So if your client purported to have a grazing operation, the county goes out there and sees a few dozen goats. It's apparent on its face that this isn't kosher, this isn't right, then this statute doesn't get that, your client in that instance, past the reasonable expectation prong. Is that what you're saying?
I think that's a different issue because the reasonable expectation within the statute, there is active use, there is a carrying capacity, there are a feasible number of
Let's
units.
assume those are all.
I think your question is more proper to those prongs.
Well,
but as to the
let's say those are
expectation,
met. You have a certain number of head of goat,
Uh-huh.
and they're grazing. The problem is it's a ruse. It's someone who is looking for an 80% tax break, holding out time until they can build a condo. In that instance, where the deficiency, in my hypothetical, the problem is it's a ruse. There is no expectation of profit. It's you got the head of cattle or goat. Yet your client signs this affidavit after 2012. You seem to be saying that the legislature didn't conclusively resolve that prong with the statute. Meaning the county can still come in before you get your 80% lower tax rate and say, hold on a second, prove this up, even though your client signed that affidavit.
well, I think if there is evidence that the affidavit is false, then I think that would just be the same as any other affidavit or false statement to a court. If you could prove that up, if you could prove falsity, then I don't think the court gets to blindly say, this is a sham affidavit, we have to take it at its word. I don't see that as being a legislative intent. I see the legislative intent as being exactly what happened here, which is where the owner signed the affidavit. There is ample evidence in the record that it is not a sham. To the extent that they think it is a sham, then they have to direct that towards proving the sham piece, which they never did. The credibility of the witnesses goes towards the court. The court found ample evidence of credibility. The court didn't find any evidence of sham. They made the argument that it was a sham without developing it.
But this is on summary judgment, and the summary judgment is just, I filed the affidavit, therefore the requirement is satisfied.
Right, and the court accepted that because on its face there was no testing. I think it was appropriate because there was no showing at all that there was a sham or no evidence that it was a sham.
But the county's now saying that we want to do some discovery to show that that's simply not accurate.
But they didn't do it.
Aren't they cut off from doing it because there's a motion for summary judgment that says this satisfies the requirement?
I think what they could have done when we filed the cross motions is said, Rule 56F, we want to go after Mr. Yount right now because we don't think this is right.
But and it would presumably be a different standard. You've got to prove this is a fraudulent affidavit. We're not
Yes,
just talking
exactly.
about there's
Right.
This may or may not be reasonable to be that a reasonable person would not think that they're going to get a profit, but it has to be a fraudulent affidavit. It seems to me to be a different inquiry than just did somebody sign something saying, I'm hoping for a profit from this. I'm sorry, that's not really a question.
Yeah, I think we're saying the same thing. For the affidavit to be a problem, you have to go down that this affidavit is a sham and is fraudulent. And there's nothing in the record here at all to support that.
What about the argument that what if you interpret this statute as it reads? Okay, it uses the word shall, right? Is it a reasonable interpretation to say that the legislature said, if you sign this affidavit, you establish, good news, you've established that element, continue down the road. And that only retrospectively can it be challenged or pursued criminally or even seeking some sort of restitution. Is that a possible or reasonable interpretation of the statute?
Only retrospectively it can be challenged? You mean after you've put the...
So your client has 4 things they have to prove in order to get this
Okay, yeah, I'm following you.
classification.
Yes, I think that is a reasonable reading of the legislature. That as to this element, I mean, remember that the tax statutes are all, and the taxing scheme is all defined by the legislature. The legislature defined one of the elements that you have to show to get agricultural classification, which is a reasonable expectation of profit. It then said, one of the ways that you can show this is by filing this affidavit. What the county wants is prong number 1, but they don't like prong number 2. Well, I'm sorry, that's the legislature issue.
Where in that 2002 statute, the shall statute, does it say that this can be litigated on the front end, even if an affidavit is signed?
It doesn't.
But presumably would be a different proceeding where the county could pursue a claim of fraud in an affidavit.
Oh, yeah, okay, I guess, yes. I'm following your, yes, I think that's right.
Retrospect, I mean, you receive your classification.
Yeah, I mean, let's not forget, I'm sorry, I think I'm catching on to your original question now, Judge Katan. The fact of the matter is, the penalty provisions in 42-12-157 on the affidavit and the filing of the false affidavit, they only come in if you already have ag status. If you don't have ag status, then there can't be a penalty provision because you're not going out of ag. Does that make sense? In other words, you provide the affidavit pursuant to 12-152C. If you can also prove up the other elements, you get ag status. If then they decide that there is a sham affidavit of some kind or a fraudulent affidavit and they want to come after you pursuant to 42-12-157, then they can do that. But they just didn't develop any of that information. And the statute's plain on its face, and the judge said, yeah, no, this is what the legislature...
Nothing that keeps them from doing that down the road. If they find some evidence of fraud, they can pursue a claim.
That's exactly right. If this court upholds the tax court's ruling, and they think that they can somehow prove that Mr. Yap signed off on a false affidavit, they have a remedy for that. The other piece I'd like to just quickly address so it's not confusing is, so Mr. Yap signed that affidavit, right, because the statute says that, and he filed it on DOR forms. There is also another affidavit in the record that was presented at the motion practice. That's from the rancher himself, Mr. Bush. Mr. Bush, during his deposition, said he couldn't remember what he'd made. He could remember $55,000 one year. He couldn't remember the others. But he also put an affidavit into the record during the motion practice there, laying out what he'd made over the various years. So there's this kind of assertion by the county in its papers that somehow Mr. Yount couldn't know what he was talking about, but there's absolutely nothing in the record to support that bare allegation from the county. That goes to the one prong of the reasonable expectation of profit. As to the other prongs, which were all decided at trial, I think in this case it's fairly straightforward that the court gives great credence and deference to the trial court in terms of the trial court's view of the witnesses. It was a bench trial, credibility of the witnesses, the evidence that came in, And I would direct you that, Judge Whitten made a lot of findings of fact in support and laid out his decision. And if you look at page 12 through 17 of the answering brief, we went through and essentially every point he made, we gave you citations to the record to support each of his findings. The standard of review here on those kinds of findings is to give great deference. You don't second guess him on that. It has to be clearly erroneous to overrule him on those kinds of findings. And
could I ask you about the finding regarding economic feasibility?
the which, sorry?
Economic feasibility.
Yep.
That it contained an economically feasible number of animals. Does that require expert testimony?
I would say two things. I don't think it does, and to the extent that you have a rancher testifying that's been out there for 40 years, working a property and ranching on 70,000 acres, the judge can certainly view that testimony from who is both essentially there as a fact witness, but can certainly recognize the expertise of that fact witness in making that determination. And his testimony was that on his ranch, Rancho Sueño, Trial Exhibit 10, you can look at that. He personally owned over 100 cattle on 1111, 1112, 1113. Part of his ranching business was not only his own cattle, but running other people's cattle, for example, Mr. Prosser, and also subleasing the property separately to maintain the ability of the property to hold water, to grow forage, and to maintain fences. And that all came in and was essentially uncontested. And so all those findings in there, in fact, I think it's interesting at the, one of the conclusions there, Judge Whitten talked about and quoted from the agricultural manual put out by DOR, and he quoted a large paragraph there on functional contribution and said this seemed like it was written for this particular rancher.
Tell me something, counsel. Are we to consider the reasonable business sort of practices of ranchers, that these aren't folks that have an in-house CPA that documents line item by line item, and that has some significance in the overall question of whether or not and what's needed to establish a reasonable expectation of profit?
Well, I think what's needed to establish a reasonable expectation of profit pursuant to the legislature is the affidavit. That's the first thing. You have to get past the affidavit in some fashion. Prior to the changing of the statute, there were several prongs as to going to a reasonable expectation of profit that would be inquired into. Part of the reason that when you look at Senator Griffin's testimony, part of the reason that they put this in there is because there was too much time and too much effort being put in trying to get ranchers to dig into paperwork that commonly they don't want to give up because they feel it's very confidential and personal information, or, as you know, they don't have CPAs dripping, at the fingertips.
I'll ask another question. If the only purpose of holding the land was to have a backup, have some backup grazing, I think there's some testimony that it's used in part in case some other land, as part of an overall operation.
Yep.
But there's no evidence of that this one's actually being used now, but it's just there as a backup in case this other land is insufficient. Would that be enough to establish economic feasibility?
Well, let me preface my answer by saying that's not the evidence in this case. Okay, this case, the evidence was that Mr. Bush did use the subject property and did use it in conjunction with the rest. if in a hypothetical situation there was no use for 3 of the 5 years and no active production, I think you would struggle if there was, you would have to then have the testimony as to why the rancher needed that. And at that point, it would be based upon that rancher telling us, well, I need it because of whatever it is.
Counsel, you have clients in other counties that are going through this similar, seeking the agricultural designation?
We do, Your Honor.
How have those counties responded or interpreted this new statute of 2012?
As far as I'm aware, Pinal County is the only one where we have this issue. So, sorry, to go back to your question, Judge Catini, that hypothetical would require then that rancher to be explaining to us, who are not ranchers, why he or she may or may not need that parcel. And
it still may be a discretionary call, you're saying?
It could be, because the rancher may be able to explain, look, I've been lucky for the last 3 years that, you know, I haven't had to move the herd because we've had unusual rains. You know, one of the pieces of testimony in this throughout is the reason that the rancher diversifies so much all over the state is because you don't know where it's going to rain, you don't know where the food is going to be and the forage, and that you need to be able to move the cattle, and that he does that. So yes, I think that would depend on the testimony in that particular position. I will note that the assessor representative agreed with the rancher and noted during his deposition and admitted at trial that having non-contiguous parcels 60 miles apart is acceptable range management practice for this very reason, because we're doing desert farming. See, my time is up.
Thank you, Counsel.
Thank you.
A couple of things that I think we need to bear in mind here is how this case came to be in court in the first place. There were 3 cases that were consolidated, 2 earlier tax years where the assessor had denied agricultural status to this property. So the assessor had been out there every year, multiple times, looking at the property, not seeing sufficient evidence that the property was being grazed or used in an agricultural way, and had been denying. We settled those earlier cases, so they're not a part of this hearing before you today, but they were there. The affidavit in question, again, signed 2.5 years after the data value in this case, and it was used retroactively. The trial court actually wanted to use it retroactively for all 3 years. So there is another question here, is how far in the future can we go? If somebody comes in today and signs an affidavit of reasonable expectation of profit, can they go back 7 years, 8 years, 10 years, and say, in the 100 VAL VISTA case, the judge applied it retroactively, and this was upheld on appeal. The SMP2 case says, no, you can't do that. We cited it over and over again in all of our pretrial memorandum to the court, and brought it up again at trial when an exhibit that was created, not the affidavit, but a different exhibit was created that was post the date of value. And even though it had been cited over and over again to the tax court prior to trial, during trial, the tax court said, I'm not familiar with this case, I don't understand it. And so we gave him a hypothetical that mirrored the facts of SMP2, and he said, oh, that's a perfect example. I would have decided it differently than the Court of Appeals did. And so the retroactive application of the affidavit is based on a trial court that refused to follow the rule of law set by this court.
You would acknowledge that you can hear evidence that's presented for the first time 2 years later, 3 years later. There's, if they present some documentation, if they go back, here's the evidence. Here are the records. If we didn't have this new statute, you're necessarily doing it after the fact. You're coming up with something. Why can't somebody come in with an affidavit that says this was, yeah, I've always had a reasonable expectation of profit?
Because the affidavit says right on its face that it's to be submitted to the assessor before the property is eligible. The statutes use that word. Property is not eligible for agricultural status, and then goes boom, boom, boom through the list of things that make it not eligible. And economically feasible is one of those requirements. So here we have a situation where at trial, our hands are tied behind our backs. We can't talk about no Schedule Fs. We can't talk about no canceled checks, which we did talk about them, but in a different context. In the carrying capacity issue, the lease was premised on, the lease payments are premised on the number of cattle actually grazing. And the rancher admitted that he had canceled checks for his lease payments, but would not turn them over to us. The taxpayers had to have those records as well. They would not turn them over to us. The burden of proof is on the taxpayers. And the county has a presumption of correctness in its valuation and classification. The only way you get over that presumption of correctness is if you present sufficient, competent evidence that the assessor was wrong. So here we have a rancher, the only witness for them, who testifies to one thing at his deposition, tries to cure it with an affidavit after the deposition that contradicts the deposition, but then at court, he testifies honestly and says he cannot recall ever making a profit. If he can't recall ever making a profit in 40 years of cattle grazing, then there's no reasonable expectation of profit, and the property that is before the court is not economically feasible. The functional contribution is a functional contribution. It's not a speculative contribution.
Bad business people are not entitled to favorable tax treatment.
Again, Your Honor, I have to go back to it being an objective test. And if they give us no documentation, don't forget there was one expert witness in this case. The court said there wasn't anybody to contradict Mr. Bush. Well, there was. Mark Finley submitted a report, and by stipulation of the parties, he didn't have to come to court to testify. But his report's in evidence, and he says there's no economic feasibility in land in this area, can't support a cattle grazing operation. I would love to talk some more, but you probably don't want to hear from me because my time's up. Thank you.
For your informative arguments, counsel. We will have a decision in due course, and with that, we're adjourned.